I received a waiver of citation. What do I do? Well, as in all things law, it depends. So let me give you the condition precedent, the situation that caused you to get. Someone passed away, and if there was no will, you might be entitled to inherit. So someone passed away with a last will and testament, and inside of a last will and testament, there is an executor. The executor has to get appointed to handle the affairs of the estate, to take assets that were in the individual name of the decedent, the person that passed away. So they have a house, they have a bank account, stock, bond, brokerage account, something in their name, an asset in their name individually, and it's stuck frozen in that person's name. So the executor of the will has to get appointed to become the fiduciary, to become the responsible party for the estate, to handle those affairs, the matters related to the estate. And part of the court process is you can file a citation. That's like hello, there's a court proceeding, right? You're citing someone to come to court. The alternative to that is that instead of citing the person, sending out legal process, you can send them a waiver. And they say, I consent to this person being the executor. I'm not going to object to the will. Now, there's that scenario. And then there's the cousin to that scenario. If a person passes away without a will, a loved one, a family member has to file to be the administrator of the estate. It's a cousin of the executor. Right? It's the same type of role, same fiduciary responsibility, taking care of assets that were in the name of the deceased person, taking care of the affairs of the estate. But instead of being an executor because there was a will, you'd be the administrator in an administration process when there's no will. That person died intestate. So a citation, we're filing papers to administer the estate, or the proposed administrator can send you a waiver of citation where you say, I consent. I have no objection to that person becoming the administrator, and I think they'll do a fine job. So what would you do if you received a waiver of citation? Going full circle. If you had no objection to the will and you trusted that person and you thought the will was done in a valid way, then you sign the waiver, return it to the attorney for the estate. And by the same token, if you are satisfied that the person that's the proposed administrator can do a fine job and you have no objection to that person handling the estate administration, then return the will. If you need help, if you want to object to a will, if you want to fight the will, reach out. If you want to consent to the will, you just want to make sure that all of the I's dotted and the T's crossed, reach out. As you can see, whether you want to fight or whether you want to consent, you should reach out to me. Deadlines abound. If you send a demand letter, it gives an expiration date for you to receive back documents or an action to be taken. If you have a client buying a house, you have to get a mortgage. If there's a mortgage contingency clause, you have to get a mortgage within a certain date. If you're setting a closing, there's an on or about date or an on or before date or a fixed date if it's a time of the essence declared in advance. So deadlines. If you have litigation, you're filing for a divorce, there's a summons with notice. The other side has to reply within a certain period of time. If you do a summons a complaint, the other side has to submit an answer. And that's the document. It's called an answer within a certain period of time. If you file a guardianship case, all guardianship cases start with a rapid pace, and you file by order to show cause, and there's a date set at the outset. Deadlines are all around us. Now, does that mean that you can't get extensions or delay? And if there are so many deadlines, why do court cases last so long? Well, they really do. They really do for a variety of reasons. So a counsel may ask for additional time to submit documents or prepare documents or to obtain information. There may be a discovery period of time. Discovery is where information is exchanged and you take the process of discovering some of the underlying facts, and that takes a certain period of time with some extensions. There may be depositions. Depositions are where opposing counsel questions my client and other witnesses, and vice versa, or reversal of fortune, I get to question the other side and other different witnesses. Even when a case is concluded and there's been closing arguments, oftentimes there are summations. Summations are the written, each side makes written arguments where they advance their positions, and there's time provided for that. Matter of fact, I'm involved in one such case, and one of the counsel asked for time to submit, additional time to submit their summation, and the other side consented because they need time as well. So this happens all the time. Deadlines. Now, you can't blow a deadline. You can't miss a deadline, but you can request an extension of time, and with good cause. And I'm a busy person. That might be, I mean, if that's the application, I need more time because I'm busy. I don't know. That may or may not fly. But if you then explain this trial came about, this other circumstance happened, this illness, this condition, right? Some of the stuff of life, legitimate reasons to request an extension. Deadlines meet and exceed expectations. Reach out, take a look at the website, frankbrunolaw.com.